So I welcome you all to another guest lecture of the Judges Guest Lecture Series of the Global South Network that I've been leading and running since March 2023. I'm Dr. Nauman Rayat, the founder and convener of the Global South Network, and the organizer and moderator of today's guest lecture. I'm a lecturer in law at the Leicester Law School, University of Leicester. My research interests include but are not limited to judicial independence, the rule of law, judicialization of politics, and constitutionalism. I established Global South Network on 17 March 2023. It consists of academics, including staff and students from different schools and colleges of universities across the globe, and actors outside academia. It is aimed at empowering people from or focusing on the Global South. As of today, it is the only international interdisciplinary network that organized around 70 knowledge exchange activities, including 4 international hybrid conferences, around 60 high-quality online PhD in progress panel discussion seminars, 12 guest lectures of the Supreme Court judges from different countries, created a team of conveners, established an interdisciplinary advisory committee, activated the website and YouTube channel, and created editorial board of the network blogs and thematic and geographic groups with just over a year of the network's launch. The social, political, economic, and legal issues of the Global South received due attention during these activities. One of the areas of the Global South that has recently received world's attention due to various reasons is the Middle East. In this regard, in my capacity as the founder of Global South Network, I previously organized and moderated the guest talk of Honourable Justice Ali Jamil Mohanna, President, Supreme Constitutional Court of Palestine. His talk titled The Supreme Constitutional Court of Palestine, Past, Present and Future on Tuesday, 7th of May 2024. Today I am honored to have Honourable Justice Ruth Ronnen, the Supreme Court of Israel, as our guest speaker during the Judges Guest Lecture Series of the Global South Network. Justice Ruth Ronnen was born in Israel in 1962 during the years 1980 to 1982. She served in the Israel Defense Forces. She completed her law studies at the Hebrew University in Jerusalem in 1986. In 1988, she was admitted to the Israeli bar. In 1990, she was admitted to the New York bar. In 1990 to 1991, she practiced as an associate attorney in New York. She was appointed judge of the Tel Aviv Region's Magistrate Court in June 1995. From 1998, she was an adjunct lecturer at Tel Aviv University. In September 2002, she completed her master's degree in law at Tel Aviv University. In May 2005, she was appointed judge of the Tel Aviv District Court. During the years 2010 to 2012, she served as judge of the Economic Department at Tel Aviv District Court. In June 2022, she was appointed Supreme Court Justice. Now I invite our guest speaker, Honourable Justice Ruth Ronnen, to deliver her lecture titled Being a Judge in Israel, Taking Judging Seriously. Over to you, Honourable Justice Ruth Ronnen.
So thank you very much for inviting me, and thank you for the opportunity to discuss with this audience what being a judge means to me. So my plan for this short talk is to talk about several things. First of all, I will tell you a little bit about myself, my personal biography, and my professional biography. And then I would like to discuss with you a few dilemmas regarding the judicial decision-making from my point of view. I would like to talk about decision-making regarding the facts, what happened, decision-making regarding the law, what is the law regarding to the facts and how it should be analyzed and implemented. And in the end, I would discuss a little bit decision-making in a situation of public debate and controversy, in Israel and anywhere else. So let me start with my personal biography in short. I was born and raised in Israel, in Jerusalem. I went to law school in the Hebrew University in Jerusalem. And after that, I clerked for the person who was then the Chief Justice of the Supreme Court, Justice Shamgar. I will mention him later. Then I went to work in a big law firm in Israel. I worked there for several years, and I also worked for a year in a big law firm in New York City, where I took the bar exam there. And after working several years as a lawyer, I thought about what my career plans should be for the future. And after reviewing in my mind a few options, I thought of the option of trying to be a judge. And I realized this is the perfect thing for me. And luckily, it worked out, and I was elected as a judge in 1995. I was a judge in the beginning in the magistrate court in Tel Aviv for 10 years, and then I've been a judge in the district court of Tel Aviv for another 17 years. So I have a lot of experience as a judge, not in the appellate division, but in the court itself. And after 27 years of serving as a judge in the magistrate and district court, I was elected 2 years ago to the Supreme Court. The thing that people most often say when they first hear that I'm a judge is, wow, it's probably so difficult to be a judge. You have to make decisions all day long. So it's true, I make decisions. This is my job. But it's always very surprising to me that people mention the difficulty of making decisions only regarding to the judicial profession, because people make decisions in many other professions, decisions that are crucial to people's life, maybe more than judges, but at least as crucial to people's life as judges' decisions are. So doctors make decisions, and engineers and CEOs of companies and bankers and psychologists, almost in every profession, people have to make decisions as part of their daily work. But people only mention judges as a profession where you have to make crucial decisions. And I think there are a few differences between the decisions that judges make and the decisions that people from other professions have to make. First of all, when we judges make decisions, we are obliged by a certain set of rules, procedural rules and substantial rules, and we have to follow them. We have an analytical way to make the decisions. And another difference, which is, I think, very crucial and important, is that we have to explain our decisions, and we have to explain how the decision fits the certain set of rules that we have to go by. And this for me, makes our decisions easier, because I know how to make the decision. I have a path that I have to go by. And if I went by that path and I can explain, and the explanation makes sense to me, then I'm fine. I know that I made the best decision that I could, as opposed to maybe other decision makers in other professions. So the first thing I want to tell you is about my first day as a law clerk for the Chief Justice of the Supreme Court in Israel, Justice Shamgar. That was the first time that I was in court, and I had to make a judicial decision. And Justice Shamgar called me to his chambers, and he told me to do the follows. He said, there is a big pack of files outside my office. Pick any one. It was a file of civil appeals that had to be decided. And he said, you can pick any file and start reading it. First thing you do is you read the appeal. You read it through, you think about it, and then you probably say to yourself, that makes sense. the appeal makes sense, there is reason to what the appellate is saying. The second thing you do is you read the reply, and you read it thoroughly, and you finish reading it, and you will probably think to yourself, that makes sense as well. There is this reason to what is said in the reply as well. And then you have to decide. And I think this advice is the best advice I ever received as a judge, because this is the whole theory of judging in 2 sentences, I think, because it says both things. First of all, what it says is that you have to be there in the dilemma and to be in the hesitation stage where both parties seem right to you, and you understand why there is logic and reason in what one party is saying, while there is also logic and reason in what the other party is saying. Because I truly believe that usually, especially in civil cases, both parties come to court believing that they're right, that their case is just. And you have to understand that, and you have to be there in this understanding and in this not knowing what the right decision is. And then comes the second stage, which is not contradictory to the first stage, but it follows it. And the second stage is start making a decision. There is a long way to go. Sometimes it's easier, sometimes it's more difficult. But at the end of that road, you have to know how to decide. And judges, to my opinion, need to have those 2 characteristics at the same time. They should know how to hesitate. They should not be politicians. We don't come in with pre-agenda of how we should decide, but we should also know how to decide. Not everybody has these characteristics, and you cannot be, I think, a good judge without having both of them. So now, that being said, I will start telling you a bit about more specific issues the judges confront with and that I confronted with during my years as a judge. And I will give you some thoughts about what I think about these dilemmas and how to think about them. So usually the first thing a judge, not an appellate judge, but a judge in the magistrate court or in the district court has to do is to deal with the facts, to tell oneself the story, what happened. And in order to do that, we have evidence, and we have all sorts of evidence. One of the things that we are faced with is the testimony of the witnesses. And one of the big questions that judges face is how to treat the testimony of the witnesses, or in other words, how to know which of the witnesses is telling the truth and which of the witnesses is not telling the truth, or sometimes maybe lying. And I think it's a big question because there are two ways of thought that judges think about such a dilemma. There is one group of judges that would say, and I know a lot of judges that think so, that in order to know whether a witness is telling the truth or lying, they look at the witness, they look at the way he talks, they read his body language, they seek the signs of truth in the way he's telling the story, and then they know. There is another group, which I belong to, that think otherwise. As I said, I've been a judge for many, many years. I've seen hundreds or maybe thousands of witnesses. I speak a few languages, but I don't speak body language. I do not know about a person that I've never seen before. This is my first meeting him. I do not know, and I cannot tell whether this person is telling the truth or is lying according to the way he is talking. And when I talk to judges that say that they can know, I ask them, how do you know? Let me know, explain to me. So if a witness is hesitant, does it mean that he's telling the truth, or does it mean that he's lying? If a witness is speaking quietly, or if he's speaking out loud, if he speaks fast, he speaks slow, whether he's scratching his head with his left hand or with his right hand, what does it mean? And how do you know? How do you know in general? And how do you know about this specific witness that you've never seen before? Maybe he's speaking quietly because this is the way he speaks always, or maybe he speaks quietly because he's lying. You never know. Also, empirical researchers proved that usually people that think that they can detect lies are wrong, and they cannot do so. And from groups of people that have been checked about trying to detect lies or truth, judges have been one of the groups that are worse in detecting lies than other specific groups like policemen or other people. So the pretense of knowing whether a certain witness is lying or telling the truth is usually a false pretense. And I think it may be based on stereotypes and of thoughts that are irrelevant to the issue itself. And we should be, I think, very, very careful before using our intuition and before thinking that we will be able to detect lies only by looking at the person and looking at the way he gives his testimony. I think that the right way to determine the facts is the legal way, the analytical way of just looking at the evidence, the hardcore evidence, and making the decision according to it. First of all, I think a judge should not pretend to know exactly what the truth, as far as there is a truth about what happened, is. A judge should try to make a decision regarding the evidence and to build an analytical legal decision regarding the specific evidence as to the factual basis of the decision. And what a judge should do is look at the affidavits, look whether there are contradictions in the testimony of a specific witness between what he says now and what he said in his affidavit, maybe whether there are contradictions between the affidavit and other evidence like letters, pictures, whatever evidence from real time, and all other matters that can be regarded not only by the judge that heard the witness, but also by any other person looking at the whole group of evidence that has been shown to the judge. This way, the judge can be convinced that he's not being led by stereotypes, and the parties themselves, whether the judge did or did not believe their testimony, can know why this happened. Because if a witness is telling the truth, but the judge did not get his testimony, he can know that why this happened. It's not because the judge thought that he is lying, but because there was a contradiction between what he said and what another witness said, etc. It's not magic. It's something that can be followed reasonably and logically, and can also be followed by the appellate division that can check the hearing judge and make a rule whether the decision was a just one and a legally correct one or not. So this is the first advice I give to new judges, and I think it should be followed by all judges. Be very, very careful when you believe that your intuition directs you in the right way to knowing what happened and to knowing which of the witnesses is telling the truth and which of the witnesses is lying. Even if you do so while writing your decision, explain to yourself, explain to the parties, and explain to me, if I'm your appellate division, why you reached the decision that you reached, so that everybody can know why you thought that this witness is telling the truth and why you pretended to detect another witness as lying. So this is my piece of advice to new judges regarding how to determine the facts. The second thing that a judge has to do is to implement the facts after we went through this stage, to implement the facts on the legal situation and to determine what the law regarding the facts is and how it should be analyzed. So, of course, I'm not going to discuss with you in detail specific legal questions, but I'm going to tell you one small story about the way I think about the legal solution to a legal dilemma. And the story has to do with my son, my older son, Uri, who used to go to kindergarten, and my talks with him and what I learned from these talks regarding legal decision making. So the story goes as follows. My son Uri used to come back from kindergarten. He was 5 or 6 years old, and I used to ask him, Uri, how was your day in kindergarten? And his answer used to be, very long answer, fun. I wanted to have a longer conversation with him, so I thought maybe I will give him an example about discussing my day at work and telling him in a bit more detail about my day and what I did during my working day. And what I used to do during my working day was to make legal decisions. So I said maybe I will tell him about a decision that I made, a case that was heard by me at a specific day. Now, the nice thing about telling a child 5, 6 years old, even if he's my own child, about a legal question is that when telling him the story, you have to tell the story in a way that has no legal nuances. It's the basic story of what happened, what the parties did in a very basic way. And when I used to tell him the story this way, I didn't do it that many times, don't be worried about the mental health of my child. It was 2 or 3 times, because after that I realized that I don't need him and I don't need to tell him the story in order to do what I'm going to tell you that I did. So I am telling him the basic story, and then I used to ask him, Uri, what do you think? Who is right? Which of the parties is right? And he used to say either one of them or the other one. And what I used to think is that it's very interesting to look at the legal dilemma this way, while checking it through the eyes of someone who does not have anything to do with the legal profession. He can be a 5-year-old child, it can be anyone else, and he just hears the story, what happened, and then he has this very basic intuition about what the legal solution should be. Sometimes the legal solution that I reached after the very long path of analyzing the procedural question and the substantial questions used to be the same as the answer of my son to the question, who do you think is right? And in these instances, it's fine, and it means that no more thinking has to be done. But sometimes my son's answer used to be different than my answer. And what I thought is that it's a good way to check myself and to check why the intuition of someone who is not from the legal profession is so different than the legal answer, and whether there is something we can do about it. So sometimes there is nothing we can do about it. It's okay that the intuition of someone who is not a lawyer is different than the right answer from my point of view of the law. Sometimes a bank has to evacuate a person from their apartment because they did not pay the mortgage, and it's fine. But if it's not fine, there are sometimes legal tools that you have to consider using if there is a very big gap between the basic intuition and the legal solution, and there has to be, I think, another thought about using these legal tools in the right instances in order to get to a solution that is also the right solution in the eyes of people who are not part of the legal profession. And as I said, I did not use my son very often. I just did it 2 or 3 times. But until now, when I have a legal dilemma and when I go through a very long path of making a decision, which has a lot of sub-dilemmas within the decision, whether this procedural issue should have been like that or not, whether this legal question has to go by a certain precedent or another precedent, whether the interpretation of the law should be like that or like this. And then I have the final answer, the bottom line. What I do is I'm telling myself, now throw away all of the legal thinking and just tell yourself the story the way you would have told it to a 5-year-old child, and does it make sense? For me, it's one of the good ways to think about legal dilemmas and to make sure, again, that what I decided makes sense and is the right decision. The last issue that I would like to address is the issue regarding legal questions that are in public controversy. So this has to do maybe with what I said in the beginning of my short talk regarding the way judges make decisions. For me, the fact that judges make decisions while using a very strict set of rules is a good is comforting, because I know the system, I know the way that I have to go through, and I know how to check myself while making those decisions. So I know decision-making, judicial decision-making is not binary. There is not always only one right decision. Judges can have disputes between themselves while all judges speak the same language, and still one judge can reach a complete opposite decision to another. But still, the fact that we have to speak the legal language and we don't reach our decisions using only some sort of intuition, I think it is a good way to make sure that we are not following a certain way of thought just because it's more popular or less popular. And I would like to say a few words about popular demand regarding judicial decisions. So there is one good thing to say about being a judge, and that is that when you make a decision, there is always one party who would say that this decision is right. When I talk in court and I explain to the parties what I think, there is always one party who nods, and I can hear him saying to himself, wow, this judge is so intelligent, and what she's saying is completely correct. The bad news is that there is another party which says out loud, or maybe think in their heart, that this judge doesn't know what she's talking about, she's completely wrong. This is the way things go when there is a controversy. Judging is all about dealing with controversies and not being afraid of them, not being afraid of hesitating, and knowing that there is a right point of view in each of the parties' claims, and deciding while using the method of decision, and while having to write down the decision in a way that writes, that makes sense. And I think this is our anchor. This is our compass, and this is what leads us leads me to be sure that I'm doing my work in the best way I can make it, because I always read my decision thoroughly before I sign it, and I ask myself, did you convince yourself? So if I convince myself, I'm fine. On the other hand, there is the public voice, and the public voice is heard by judges because judges are part of the public, and the public everywhere, and the public specifically in Israel, don't think about specific questions the same way. And it's okay, controversies are fine. At least I am not afraid of controversies. When I was a law clerk, it was many years ago, some of the justices used to say they don't read newspapers because they don't want to be affected by what the newspapers say. I don't think it was right then, but it's obviously is not right now. We do read newspapers, we hear the news, we read the internet, I sometimes even read talkbacks, and we are aware of the public voice, and it's okay. I think it's okay to be aware of the voices that are heard outside the court. It's okay, and it's even important to be aware of it, because the way to not be affected by popular demand is, first of all, to be aware of the popular demand, and then to be cautious and to make sure that this demand is not what leads us, what leads me to reach a certain decision and not another decision, because what should lead me to reach a certain decision and not another decision is the law. And when I was sworn to be a judge, I promised to follow the law, and this is what I'm trying to do. The voices from outside, which sometimes are heard by me, not in a metaphorical way, but in an actual way, because sometimes there are demonstrations just outside my window, and I hear them, I actually hear them. And I know that there are demonstrations that would be in favor of one sort of a decision, and maybe other demonstrations that would be in favor of another sort of a decision. All of these demonstrations are legitimate, but my decision has to be made disregarding them. And as I said, disregarding them has to, first of all, go through the procedure of knowing that they exist, and then making sure to put them outside of my way. And the right way, the safe way to do it is, as I said, by going through the analysis, the legal analysis that we know how to use, and to write it down and to explain it, and to convince, first of all, ourselves, and then hopefully some of the public, but even if not, the judge has to be sure that he made the right decision. I think I should stop here and tell me how we should go about with the questions. If you want to ask.
Yeah,
okay, I can hear you now.
Oh, you can hear me? Great, fantastic. Okay, so I will start with thank you very much for such an insightful talk. Your talk certainly contributed to our knowledge about being a judge in Israel, and I really like that how you related your experience of making decisions to your conversations with your son. That was very touching. So, having said, let's go for the question and answer session. I can see some hands have been raised. But as I announced previously in my emails and my announcements, that in order to ensure equal, diverse, inclusive, and safe environment, I invite people to submit their questions in advance. And I did the same with the previous guest lectures, and I am doing the same with this particular guest lecture. So I did receive some questions, and I'm going to read out to you. I think one of the questions is very slightly historical comparison. So the question is, how do you see the difference between today's Supreme Court of Israel and the one during the Chief Justiceship of Aaron Barak in terms of the court's ability to protect human rights and public support?
Okay, so thank you for this question. There was a Chief Justice of the Supreme Court that used to say the translation of the word court in Hebrew, the basic translation is House of Justice. And this Chief Justice used to say, the court is the House of Justice and not the House of Justices. Meaning, we are not just specific people making decisions disregarding the decisions of each other. We are one institution, and we are bound by the decisions of this institution. Sometimes we are allowed as Supreme Court judges to make different decisions than other judges have made. But despite that fact, we usually try to have an institutional decision regarding basic questions that this institution has to decide on. So this relates to your question because I think the court during the time of Aaron Barak, which was probably one of the greatest justices in Israel, maybe even the greatest, and he has his rights and his place in the judicial history of Israel. But still, even at the time of Aaron Barak, as in our time, the court is an institution. And the defense, I think, of legal rights by this court is an institutional defense. And it used to be then, and it is now, I think, a very strong defense. And I don't think it's less important or less effective or more effective today than it used to be before. Because, as I said, the court is the same court. It's still the Supreme Court of Israel, the House of Justice, trying to make just decisions regarding human rights as regarding all other questions that we're dealing with.
Thank you very much. One last question, and that's a very general question. And I think that's just to want to know if so what main lessons do you think the legal systems or higher judiciaries in other countries should learn from the Supreme Court of Israel and its decisions?
Wow, I thought you were going to say the other way, what we should learn from other legal systems. But generally, I think that legal systems should learn from each other. I used to be, I didn't tell you in detail, but when I was in the district court, I used to be a judge in a department that was called the economic department. And it was a new department that was built on the based on the system of the state of Delaware in the United States as a corporate court. And we used to read a lot of decisions from the Delaware court, and we tried to learn from their experience. Now, we were not obliged by their decisions, and we could rule otherwise, and we did our thing the way we thought we should do it. But I think it's very it broadens your horizons to see how other judges decide and how other judges in other countries decide. So I think we try to do it regarding other countries, and I would be very delighted if other countries would do it with us. It's always interesting, even if you disagree, even if you criticize the decisions, even if you think that you would do the same, you would deal with the same questions in a different way. But why not look at other notebooks and see what other judges are doing? I think it's always a good thing to do. So welcome to try and learn from us as much as you want.
Thank you very much. I think I don't have any other questions. Do you have any general comment to make, or any last questions?
No, I would like to thank you again very much for this opportunity. It's funny to speak via Zoom, not seeing the audience, but it was still an opportunity to share with you my thoughts, and thank you very much.
I think it's an honor for me. It's an honor for the Global South Network, the University of Leicester, to have you and the previous judge. And I think it's during the peak of the crisis, if you are able to, bring different voices together, I think that's a great milestone. And I think that is something that makes me say congratulations to all of those who attended the session and who are part of this this event. Thank you very much. I mean, your talk certainly contributed to our knowledge about being a judge in Israel. It diversified legal knowledge. Thank you very much. On this note, I would like to say, look after yourself. Have a great day. Thank you. And thanks all who attended the session. Bye-bye.